pleasant day everyone. I am Zenaida Bantilan and today I'm going to discuss about the chapter 3 of our legal aspect in tourism and hospitality, which is the obligations and contract. In this topic, we're expected to identify the different kinds of obligations and contract, enumerate the ways of extinguishing an obligation, enumerate possible application of contracts in tourism, travel, and hospitality industry. The content of these topics are obligations, elements of obligations, the sources of liabilities, sources of obligations, classification obligation, modes of extinguishing obligations, contracts, characteristic of contract, and classification of contracts. So first, let us define what is obligation. Based on Article 1156, an obligation is a juridical necessity to give, to do, or not to do. Now we have four elements of obligations, which is the juridical tie, object or prestation, active subject or the creditor, and passive subject or the debtor. The sources of liability for damages as of a party in an obligations are: first is fraud. In fraud, there is an intent to evade the normal fulfillment of the obligation and to cause damage. Second is negligence. The negligence refers here in the case of the contract is culpa contractual, the lack of diligence or carelessness. Negligence consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the person or the time and of the place. Third is delay. The debtor can be held liable for a delay or default in the fulfillment of his obligation only after the creditor has made a demand, judicial or extrajudicial, on the debtor. Fourth is the contravention of the tenor of the obligation. Performance in contravention of the tenor or terms of obligation means where performance in contrary to what is agreed upon or stipulated those makes the debtor liable for damage. Now let's talk about the Article 1157. Obligations arise from: first is law, second is contract, third is a quasi-contract, fourth is the act or omissions punishable by law, and fifth is the quasi-delict. There are only two sources of obligations, namely law and contract, because obligations arising from quasi-contract, crime, and quasi-delicts are really imposed by law. A contract is a meeting of the minds between two persons whereby one binds himself with respect to the other, to give something or to render some service. Quasi-contract refers to a lawful, voluntary, and unilateral act based on the maxim that no one shall unjustly enrich himself at the expense of another. Quasi-delict, also called culpa aquiliana, is an act or omission which causes damage to another, there being fault or negligence and therefore being no pre-existing contract between the parties. Now, let's talk about the classification of obligation. The first one is the primary classification of obligation under the Civil Code. Under it are pure and conditional obligation, obligations with a period, alternative and facultative obligation, joint and solidary obligation, divisible and invisible obligation, and obligations with penal clause. Another classification is the secondary classification of obligations under the Civil Code, which under it are unilateral and bilateral obligations, real and personal obligations, civil and natural obligations, and legal, conventional, and penal obligations. A pure obligation is one which is not subject to any conditions and no specific date is mentioned for its fulfillment and is therefore immediately demandable. A conditional obligation is one whose consequences are subject in one way or another for the fulfillment of a condition. An obligation with period is one whose consequences are subject in one way or another to the expiration of the said period of term. Joint obligations are those where although there concur two or more creditors and debtors in one and the same obligation, there is no right to demand nor a duty on the part of each of the latter to render entire compliance of the entire obligation. Solidaric obligations are those in which concur several debtors or creditors or both, and where each creditor has the right to demand and or each debtor is bound to perform in its entirety the prestations constituting the object of obligation. Now for the modes of extinguishing obligations. Based on Article 1231, obligations are extinguished first, by payment or performance. Second, by the loss of the thing due. Third, by the condonation or remission of the debt. Fourth is by the confusion or merger of the rights of the creditors and debtors. And fifth, by compensation. And by sixth is by novation. Other causes of extinguishment of obligations such as annulment, rescissions, fulfillment of resolutory conditions, and prescription are governed elsewhere in this Code 1156A. There are other causes of extinguishment of obligations which are not expressly provided under the above provision. Death extinguishers obligations which are purely personal in character, such as partnerships and agency. Obligations may also be extinguished by the happening of a fortuitous, fortuitous event or by will of one of the parties, as in some contracts such as partnership and agency. Part- Parties may stipulate any currency of payment of debt to extinguish obligation. In the absence of an stipulation, payments must be made in the currency which is the legal tender in the Philippines, the Philippine peso. This event, also known as force majeure or caso fortuito, are terms which exempt an obligor from liability. These are extraordinary events not foreseeable or avoidable. Events that could not be foreseen or which, though foreseen, were inevitable. It is based on Article 1174 Civil Code of the Philippines. We are now done with the obligations. Now let's move on to contract. Based on Article 1305, a contract is a meeting of minds between two persons whereby one binds himself with respect to the others to give something or to render some service. The essential elements of a contract are: first is a consent, which is manifested by the meetings of the mind of the other and the acceptance upon the things and the costs which are to constitute the contract. The offer must be certain and the acceptance absolute. Another element of it is the object certain, which is the subject matter of the contract, and another element of it is the cost of the obligation which is established. A contract of adhesion is defined as one in which almost all the provisions have been drafted only by one party, usually a corporation or insurance company. The only participation of the other party is the signing of his signature or his adhesion. The characteristics of a contract are: first is the mutuality of contract. Its validity and performance cannot be left to the will of only one of the parties. Second, autonomy of contract. Parties are free to stipulate terms and provision in a contract as long as these terms and provision are not contrary to laws, morals, good customs, public orders, and policy. Third, Relativity of contracts. Contracts are binding only upon the parties and their successors in interest. Exemption of this is the simulation in favor of a third person, as in a beneficiary of an insurance policy. Number 4, consensuality of contracts. Contracts are perfected by mere consent and no form of prescribed by law for their validity. Exception of this is first, real contracts such as pledge. Another one is the contracts covered under the statute of frauds. Fifth characteristic of it is the obligatory force of contract. By the obligatory force of contract, it constitutes the law as between the parties who are compelled to perform under the threat of being sued in court of laws. Now for the classification of contracts. First classification is according to the relations to other contracts. Below it are preparatory, principal, and accessory. Second classification is according to their perfection, which are consensual and real. And third classification is according to their forms. Under it is common or informal, special or formal. And fourth is according to their purpose. And under it are the transfer of ownerships, conveyance of use, and rendition of service. The fifth classification is according to their subject matters, and under it are things and services. Sixth classification is according to the nature of the vinculum which they produced, and below it is the unilateral and bilateral. The fifth classification is according to their cause, and under it is the unirus and gratuitous. The eighth classification is according to the risk involved, and under under it is commutative and aleatory. The ninth classification is according to their names or norms regulating them, and under it are nominate and innominate.